If you or someone you know is being investigated for or has been charged with endangering the welfare of a child in New Jersey, here's what you need to know. I'm Daniel Rosenberg. I'm a criminal defense attorney in New Jersey, and one of the cases we commonly handle is endangering the welfare of a child. And when I'm meeting with clients discussing the potential consequences, which include Megan's Law registration, parole supervision for life, jail, prison, they are shocked that what they're facing has these sorts of consequences. The first thing you need to know is, what is endangering the welfare of a child? Endangering the welfare of a child is a criminal statute in the state of New Jersey that covers a wide variety of criminal conduct where children are the victims. A child in the state of New Jersey is defined as a person who is under the age of 18. The conduct that's prohibited by endangering the welfare of a child varies. It can be possessing child pornography. It can be distributing child pornography. It can be creating child pornography. It is also a violation of the statute to engage in conduct that would impair or debauch the morals of a child. So what is conduct that impairs or debauches the morals of a child? That's a factual determination that's made on a case-by-case basis. Our office has represented and handled cases involving showing a child a pornographic movie, engaging in kissing, engaging in inappropriate touching with a child. But the statute also prohibits conduct that is non-sexual. For instance, giving alcohol to a child, driving while intoxicated with a child in the car, or driving a child in a car without the required car seat. All of this conduct is prohibited under the Endangering the Welfare of a Child statute. So what is the potential punishment for someone charged with endangering the welfare of a child? Well, that answer is going to depend on what section of the statute you're charged under. Different conduct, different consequences. The Endangering the Welfare of a Child statute can be charged anywhere from a first degree all the way down to a fourth degree. If you're charged with a fourth degree crime, you're exposed to up to 18 months in state prison. If you're charged with a crime of the third degree, you're exposed to between 3 and 5 years of state prison. If you're charged with a second degree, you're exposed to between 5 and 10 years in state prison. If you're charged with endangering the welfare of a child in the first degree, you're exposed to between 10 and 20 years in state prison. So the specific allegations are significant. Some of the sections of endangering the welfare of a child not only come with prison time, but come with mandatory prison time. And some come with mandatory parole ineligibility. What that means is, if you are sentenced to a period of incarceration, there's a certain period that you are ineligible for parole. For instance, you may get a 5-year sentence with a 2.5-year period of parole ineligibility, which means that you are serving every day of 2.5 years before you're eligible for parole. Or, if you're a second or subsequent offender of the statute, you can be sentenced to an extended term of imprisonment, which means you are sentenced 1 degree higher than the degree you were charged. For instance, if you're charged and convicted of a third degree offense, you can be sentenced as a second degree offender, which means you're no longer exposed to between 3 and 5 years, you're now exposed to between 5 and 10 years. And most of the convictions for endangering the welfare of a child also come with Megan's Law registration. They also come with parole supervision for life. Finally, with very few exceptions, endangering the welfare of a child is one of the limited charges that cannot be expunged from your record. So if you or someone you know is charged with endangering the welfare of a child, here's what you need to do. First, invoke your right to remain silent. Speak to an attorney as quickly as possible, because the consequences are too significant and too severe for you not to get legal guidance before you say a word to law enforcement. An attorney can give you guidance on what the next steps are in the prosecution, as well as what the next steps are or what's in your best interest in terms of a defense. Once you retain legal representation, your attorney will be able to advocate for you. Your attorney will be able to speak on your behalf, so you don't have to worry about making any statements that are potentially against your interest. Your attorney will also communicate with the prosecutor and obtain discovery, which includes all of the allegations that are leveled against you, statements, police reports, video, and any other evidence that they may have. Did the alleged conduct impair or debauch the morals of a child? Did the accused have a legal duty to care for the child? These are all significant factors in what charges are leveled against you. And what charges are leveled against you are extremely significant, because some of the statute requires Megan's Law and parole supervision for life, and some of the statute does not. For example, we had a client who was in a long-term relationship with a woman. That woman had a grandchild, and over the years, our client developed a relationship with the grandchild. Ultimately, he broke up with his girlfriend, and there was bad blood between the two families. Soon after the breakup, allegations were leveled against our client, claiming that he inappropriately touched this child. He was ultimately charged with endangering the welfare of a child along with other charges. After he retained our office, we immediately contacted the prosecutor and invoked his right to remain silent so that no statements would be provided. We then obtained all the discovery from the prosecution so that we could start building our defense. And some of the things we found were compelling. First, we were able to determine that the child made numerous statements and they were inconsistent. And finally, we took the position that our client did absolutely nothing wrong and he was not going to accept any form of a resolution. So we let the state know if they wanted a conviction, they were going to have to go to trial and they were going to have to earn that conviction by convincing 12 people beyond a reasonable doubt of our client's guilt. It took several months, nearly a year, but ultimately, all of the charges were dismissed. So if you or someone you know have any questions about endangering the welfare of a child or the consequences resulting from a charge, contact our office. We're happy to sit down and meet with you and take all the time that is needed to review your case and give you your options, and we do all of this free of charge. We are criminal trial attorneys. We have your back. That's what we do.